Welcome back for another episode of SSD Mythbusters. My name is Jeremy Worley, and here we talk about all things Social Security disability law, and we take topics and try and either prove them to be true or bust them. And we do that by asking our Social Security disability attorney, Josh Worley, who's been doing this for over 20 years, has seen and heard just about everything, so he can help us know what's true and what's not. Welcome, Josh.
Thank you. Thanks.
All right, so we do a lot of some of these are really serious, some are a little bit, sillier, but today is a little bit silly, but I think also something we got to address. So today's myth is, if I show up with crutches, I'll win my case. What do you think? Is it just a matter of bringing some crutches?
It is not just a matter of bringing some crutches. I've had clients through the years where they've kind of wondered, if I show up with a bandage on my head, or if I've got crutches or a cane or a walker, does that help? And the bottom line is it doesn't. It does not help at all. And really, the truth be told, it works against you, because now let me say it works against you if it's just for show. If you've got something legitimately going on that requires you to have crutches, then certainly do that, or requires a cane. I have many clients that need a cane, and they have a cane when they walk into their hearing or when we have their hearing. So that's perfectly fine as long as it is legit and you actually need it. But if it is for show, for a prop, just to kind of convince the judge that you're really bad off, then that is not good, and that doesn't help. And in fact, I tell my clients when we're preparing for a hearing, I tell them, you don't have to put on a show for the judge. You don't have to be dramatic. You don't have to be just over the top with your description of things that are going on with you, because the bottom line is that you can lose credibility when you do that. Because if you go in your hearing and it's like everything is a 11 out of 10 on the pain scale, and it's like when the judge asks you about your pinky, it's like, oh yeah, my pinky that hangnail is the worst ever, and it causes me so much pain. I mean, that's so just dramatic that you lose credibility, because the judge sits there and says, you know what, someone can't be that bad off. And also, what you're saying, like if you've got crutches or if you've got a cane, and it's not in your records, the judge can then look at some records from your primary care physician, and there's no mention of needing any kind of, crutches or cane or whatever it might be, then the judge will ask. I've had many hearings where there will be something that a client has, and they'll say, okay, was that prescribed? Why are you doing that? And so anything for show is not good. Don't do it. It works against you. A huge part of being successful on a disability case is having credibility. And if you're doing something for show, that affects your credibility and makes it more likely that you'll get denied.
Yeah, it sounds like it really could work against them. I mean, I think what they think sends this picture of making my symptoms look really bad. The reality is if they're seeing you on crutches, you're at a hearing level. Mm-hmm. And by that point, they have all your records. We've talked about all the steps leading up to that point. So you could really do a lot of harm, undo all the good that you had by losing credibility, and that the decision maker may ultimately question everything in your records if they find you're being untruthful or misrepresenting your condition at a hearing level.
Exactly. And I get the idea of you're really wanting to show the judge how bad off you are. I get that. If you're at a hearing level, you've waited a long time to get to that point. You really want to convince the judge how bad you are, but you don't have to do that by going over the top with things.
And I think just these decision makers, just to step in their shoes for a little bit, they're in tough positions. They're trying to assess someone based off records. This may be the first time they see them. So if there's anything that can kind of sway them, I could see how they would really latch on to trying to decipher what is the truth. And if there's anything that gives this perception that maybe they're not truthful, I mean, these decisions may come down to just a few really small things. And so it's not worth it. It sounds like, based off what you're telling us.
No, it really isn't. And that's a perfect kind of summary of everything. Every little thing matters on getting approved for a disability claim. And you don't want to do something that can really negatively impact your case.
Okay, well, crutches aren't going to be enough to get approved. But as Josh has shown us, really this thread, consistent theme throughout all of these videos is there has to be just a commitment to truthfulness and being truthful in everything. So if crutches are a part of your condition, your records, obviously we're not saying don't show up with those, but you don't want to do anything that might not be part of your record. The judge is going to know up to that point if crutches or any other medical assisting device is a part of your history. So you want to be careful with that so you don't ultimately lose credibility, as Josh says, because ultimately credibility may be what decides whether you get approved or not. So Josh, thanks for helping us. Hopefully you found this helpful. Give us a follow. We're going to continue to put out more videos with more content, busting myths. If you want to talk with our team, you can talk with Josh and our Social Security team here at the Injury and Disability Law Center, where they help clients all over the country. We'd be happy to try and help you if you have some issues with Social Security disability. So thanks for joining us. We will see you next time.